Chapter 11, Part A, briefs. Contracts for real estate transactions. Common law says contracts don't have to be in writing to be valid and enforceable. The Real Estate Services Act requires exclusive listing to be in writing. So highlight exclusive listing and in writing. Listing, lease and contract assignment agreements. Section 59 of the Law and Equity Act. Scope of the Act says in most cases all contract dealing with land or a disposition of land, highlight a disposition, must be in writing in order to be enforceable. So highlight a disposition of land must be in writing. Section 59 of the Law and Equity Act does not apply to contract granting leases of land for 3 years or less. So highlight 3 years doesn't apply to, right? 3 years or less for leases. So leases or agreement to lease don't have to be in writing if they are for 3 years or less. So highlight 3 years or less.
But ਜਿਹੜਾ 3 year ਦੀ ਲੀਜ਼ ਕਰਨੀ paperwork ਜ਼ਰੂਰੀ ਨਹੀਂ.
Let's say there, right? So leases or agreement don't have to be in writing. There are two exceptions. So highlight two exceptions. Where the party denying the contract has done some act that indicate the contract was made. Where the party denying means a person who is saying no, I never did a contract, has done some act, has done something, right, that indicate the contract was made. 2. Where the party denying the contract has agreed to an act by the other party which indicated the contract was made. John seller accepted deposit money which would indicate a contract was made, or Bob's buyer included payment of a deposit as a part of the price. So basically deposit. Even if the court finds the contract cannot be enforced, the courts may provide some relief to the party, highlight some relief, to the party seeking to enforce the contract. Bob buyer by ordering a restitution. Restitution means compensation, such as the court could order John seller to return the deposit money back to Bob the buyer, or compensation for money spent, such as legal fees. So legal fees Bob buyer had to pay to have transfer documents prepared. So basically, so the courts can enforce them to either pay the losses by the buyer, right? So next is listing contracts. A listing contract is a contract between vendor and registered brokerage. So between seller and a brokerage. The purchaser is not party to the listing contract and cannot rely, can't rely on the information in the listing contract. This is because what is written in the listing contract between the vendor and the agent is an invitation to treat. So highlight invitation to treat, less than a legal offer. Even if the realtor brought the vendor an offer of all cash, highlight all cash, no subjects, full price, the exact dates, etc., the vendor does not have to sell a house. So it doesn't have to sell to the buyer. So thus the buyer cannot rely on what is written in the listing contract. For example, if I list a property, I say I list for $699. Somebody brings me an offer for $699 cash, no subject, and same date what I asked. Still I can say no. So because this is less than a legal offer, so this is an invitation to treat. So all parties who have an ownership interest in a property are required to sign, highlight all parties, required to sign, highlight required to sign. So basically sometimes you get an opportunity where there are 5 people on the title, one of them in India, everybody has to sign. So you can fax them there, right, and he can sign it. So a title search at the land title office will show all the registered owners. When you do title search, you will find the owners. Call it title search. If the vendor has a mortgage, this should be verified with the lending institution. So normally it shows on the title. C, A, B, C, T, D, whatever, right? So basically verification of mortgage. A true copy of a listing agreement must be given to all parties. So highlight copy to all. Copy to all. So basically, if there are 5 of them, so give 5 of them.
So true copy means photocopies or
Yeah,
actual copies?
Actual copy.
True copy means photocopy of that.
So highlight true copy?
Basically, copy to all.
ਜਿੱਦਾਂ
So when you made a deal, once you made a deal, so you can make a copy and give it to them. Okay. So there is no true or false copy. Basically, mean the copy is
Just copy,
agreement. The court say that agents have positive duty to be reasonably aware of historic, highlighted reasonably aware of historic and geographic fact, which should alert them to specific problem. So historic means try your best the history of the property and the area of it. For example, in that area there is an infestation of termites because that is all forestry all around, or a water shortage in the area, for example, right? Example, a known water shortage in the area that occurs every year. So an information form accompanies the listing agreement and is used to compile additional information about the property, such as contaminated property. Right?
ਜਿੱਦਾਂ ਵੀ ਕੋਈ
Marijuana grew up.
ਰੋਣ ਗਰੋ ਅਪ ਫਲੱਡ ਆਇਆ ਜੀ
Yeah. The role of the next is the role of the Competition Act. This is a federal statute and is designed to eliminate privately imposed restraints on trade. Restraint means restrictions on trade and to encourage competition. It encourages realtors to negotiate commissions with the owner. 2 parts to the act. Number 1, agreement in restraint of trade. Highlight. The act prohibits price fixing. Prohibits price fixing, market sharing, or entry barring agreement that lessen competition unduly. Real estate companies cannot get together and price fix or set prices. Since the Competition Act became legislation in 1976, all local real estate boards, real estate companies, realtors must make no effort to set either commission rates or the splits between listing and selling licenses. Each firm must be free to set their own rates. So I had free to set.
they're free.
Yeah. Same thing commission. So there is no set. You have to pay that much. It's negotiable between the seller and the realtor. Number 2, misleading advertising, deceptive practices. According to the Competition Act, statement must make a representation to the public that is false or misleading, false and misleading in a material respect. Material means is a major factor in determining whether the representation is false or misleading in a material respect. The court must assess the general impression, conveyed by a representation. What was the general impression of the advertisement to the public? The test as to whether a statement is misleading is whether the uninitiated and inexperienced person exposed to the representation is misled. Example, show home ad says a townhouse 150,000 at 2% mortgage. When the model listed was unavailable at the advertised price and the 2% rate did not apply to the model of 150,000.